Welcome to Understanding Mental Health Forensics, Module 2, Contact with the Police and Courts. The learning aims of Module 2 are to understand the role of the police and to explain what happens in court. Firstly, contact with the police. Place of safety. The police have the power to take an individual to a place of safety for the purpose of a medical examination for up to 48 hours if the officer suspects that a person in a public place has a mental disorder, is in immediate need of care or treatment. It would be in his or her interests or necessary for the protection of any other person to remove him or her to a place of safety. A place of safety can be a hospital, premises used for the purposes of providing a care home service, or any other suitable place other than a police station where the occupier is willing temporarily to receive mentally disordered persons. If no place of safety is immediately available, a constable may remove an individual to a police station. Health services within police stations. In police custody, healthcare is conducted under the supervision of forensic medical officers, FMOs, who are responsible for deciding whether a detained person is fit for questioning by the police. In Northern Ireland, FMOs are essentially general practitioners and would not be specialists in mental health or learning disability. Where an FMO thinks admission to hospital may be appropriate, he or she may advise the custody sergeant to arrange a mental health assessment, which can lead to compulsory admission under the mental health order, or to voluntary admission. When an FMO decides a person is not ill enough to justify admission, but is at the same time not fit for custody, he'll be released, and a file will be completed and passed to social services to follow up. Fitness to be interviewed. Medical or legal criteria regarding fitness for interview do not currently exist. Factors to be considered include: does the detained person understand the police caution after it has fully been explained to him or her? Is the detained person fully oriented in time, place and person? And do they recognise the key persons present during the police interview? And is a detained person likely to give answers which can be seriously misconstrued by the court? The need for an appropriate adult. If a custody sergeant suspects that a person might be mentally disordered or otherwise mentally vulnerable, he is obliged under the Police and Criminal Evidence Order 1989, or PACE, to seek the services of an appropriate adult to represent the person's best interests. An appropriate adult should be someone who is completely independent of the police and, where possible, the interviewee. The appropriate adult scheme in Northern Ireland is provided by Mindwise, an independent mental health charity whose staff members are trained in mental health or learning disability issues. In Northern Ireland, significant numbers of mentally disordered offenders are ending up in prison when they ought to be diverted into the health service. This is because there is no recognised diversion scheme for mentally disordered offenders in the court services in Northern Ireland. So we summarise: contact with the police. This involves a place of safety, health services in police stations, fitness to be interviewed, and appropriate adult. Moving on to the courts. All cases begin in Magistrates' Court with usually one district judge. Cases can progress from Magistrates' Court to Crown Court for more serious offences. The police, defence solicitor or prosecution can tell the court about your loved one's mental health. It could be helpful to have a one-to-one conversation with your loved one's solicitor yourself, so you're aware of what will be happening and can communicate any concerns about the current mental health or history, if this would be helpful for the court to be aware. If you feel the solicitor does not understand mental health, there are some solicitors who specialise in mental health, and it may be helpful to change to one of these. It can be helpful to speak with the court usher if you have any concerns about your loved one. Ask your solicitor if you aren't sure what's happening. As part of the court process, the judge can request a psychiatric report on your loved one's mental health issues. This may help a solicitor or barrister argue the case should be stopped or services be in place for the person's mental health. This may take time, but it could be helpful if your loved one is unwell. In the case where someone is found guilty, often sentencing will be completed at a later date, and the Probation Board of Northern Ireland will be requested to carry out a pre-sentence report. As part of this report, the probation officer can look holistically at the individual, including their mental health and the situation around the offence, to recommend possible outcomes for the sentencing process, whether this be through the community or prison. You can also write to the court to ensure your loved one's mental health is considered, especially if your loved one has refused a solicitor, or the solicitor may not be giving the individual's mental health enough considerations. Some courts have a quiet, private waiting area. This can be helpful, as often can be busy and stressful for those waiting for the hearing. The learning aims of Module 2: to understand the role of the police, to explain what happens in court. This is Module 2 of Understanding Mental Health Forensics. Module 3 and 4 are available as well.